Welcome to Musca Law Radio, a program dedicated to criminal defense with attorney John Musca. Mr. Musca has offices throughout Florida, including Broward and Palm Beach counties, and has devoted his legal career to representing clients on all criminal defense matters. Mr. Musca has been a member in good standing with the Florida Bar since 1999. He's a lifetime member of the National Association of Criminal Defense Lawyers, the Florida Association of Criminal Defense Lawyers, and NORML. In 2012, he was selected as a rising star by Super Lawyers, a distinction reserved to the top 2.5% of all criminal lawyers in Florida. For the past 4 years, Mr. Musca has been designated one of the top 100 trial lawyers in Florida by the National Trial Lawyers Association. He also enjoys a perfect 10 rating with AVO, a respected independent lawyer rating organization. If you or someone you know is under investigation or accused of a crime, or if you have any questions related to criminal law, you don't want to miss today's show with attorney John Musca. To watch this show stream live, visit www.muscalaw.com and click on the radio link. Now, here's attorney John Musca.
Thank you so much. Pleasure to be here this evening. Good evening, South Florida and listeners everywhere. Pleasure to be here, really. Thank you for joining us. This is the first show of its kind. This is our first presentation, our first show, and I wanted to welcome everybody. The first question I want to answer is why did I decide to do the program, and the answer is very simple, because I enjoy what I do, and I feel that the purpose of this program could be best served by educating the public and doing everything that I can to relay my experience, what I've learned over the past 15 years practicing law, and what I could do to help others, and truly that's why I'm here. So give us a shout. We're at 1-888-565-1470. You can call into the show. We'll take your calls live, and I'll do the best I can to answer your questions within my limitations. In other words, there's certain questions that I will not be able to answer, so on account of regulatory reasons, if I decline to answer, I hope to not offend or insult anybody, but please understand that those are the rules and the limitations that we work under. However, there is quite a bit of content material that we can cover in the hour of time that we have together here this evening. So once again, 1-888-565-1470. Feel free to call into the show and ask me any questions you may. The second question that I get asked a lot, and probably the most common question when I meet people in public and elsewhere, why did I become a defense lawyer, and how could I defend somebody that I know is guilty? The answer to me is very simple. Everybody is entitled to a complete defense. If you're accused of a crime in the state of Florida, in any state, in this country, you're presumed innocent by law. That means that the law must presume that you did not commit the offense unless or until the prosecutor is able to satisfy the burden and prove beyond and to the exclusion of every reasonable doubt that you should be convicted. So that's my answer, and the counter argument to that, and what other people would say is, well, again, you know, that's all fine and good, but how can you defend somebody that you know is guilty? And my answer is, I didn't draft the Constitution, our forefathers did. And when I was admitted to the bar, I took an oath to support the Constitution, and part of that says that I'm going to defend the honor of those that are accused and those that are less fortunate. And I did that for close to 2 years as a public defender, where I think I really started developing my passion for this line of work, and everyone's presumed innocent, and that's a key thing to remember. Now, with respect to the areas of practice that we're going to cover today, we're going to talk a little bit about the criminal law process, okay, from beginning to end. First, I think it's important to recognize that when someone is arrested for a criminal offense, whatever type that is, that they're merely arrested and charged by the sheriff's office. They have not formally filed charges. That's something that a lot of people don't understand. There are stages to the criminal process. The first stage is the arresting and the booking stage, and that's when the sheriff's office makes a decision to charge. So, for example, if somebody is stopped for a DUI arrest and is cited for DUI, at that point the sheriff's office gathers their information together. They marshal together their evidence, the arrest materials. The person is then arrested, and then they're entitled to a bond. Every person that's arrested in the state of Florida is entitled to be brought before the court within 24 hours of the date of the arrest for the purposes of setting bond and for the purpose of determining if there's probable cause to warrant their detention. That's the first step. Once the person is arrested, then some people are able to financially afford a bond and some people are not. Those that are not have to remain in custody until their case is resolved or disposed of. Those who are able to afford a bond post bond, and then they await their first court date, which is called the arraignment date. The arraignment date is the date on or by which the prosecutor is obligated to make a formal filing decision. So this would be more or less the second stage. Again, here the prosecutor makes the formal filing decision, not the sheriff's office. So the prosecutor will then receive the information from the sheriff's office and make a decision on whether to pursue formal criminal charges by filing what's called an information in the state of Florida, or declining prosecution. Most cases that reach the prosecutor at that stage, prosecutors decide to go ahead and file formal criminal charges, and it's at that point that the formal action gets set into motion in court. Many people ask me about the arraignment date. Do I have to attend my arraignment date? Under the rules of criminal procedure, we are allowed to, as defense lawyers, to waive your appearance at the arraignment by filing a waiver of appearance. We also, in preparation for the arraignment, file a not guilty plea. As defense lawyers, it would be a not guilty plea, not a guilty plea. If it's a guilty plea, you don't need a defense lawyer. So we would then, in preparation for the arraignment, file a not guilty plea. We would then file a demand for all the evidence, a notice to participate in discovery, as well as a demand to request a copy of the charging document. Those filings are typically prepared and registered with the clerk of court prior to and in anticipation of the arraignment date. Once the clerk's office receives that information, then the arraignment the purpose of the arraignment is then satisfied, and then the clerk's office will then assign another court date. So ordinarily, for the typical criminal case, there are a series of court dates. On misdemeanor cases, we are able to typically file a waiver of not only the arraignment but also the pretrial conferences to allow defense counsel to represent the interests of the accused in court so that they don't have to physically appear and show up. Although some judges in certain areas would require you to appear in either case. So definitely make sure that you consult with your defense attorney first before you decide to just not show up to court. The next stage after the pretrial conferences, we move toward a trial date. Judges typically like to get cases moving along. They don't like cases on their docket for an extended period of time, and defense lawyers know it. So whether it's a felony or a misdemeanor, we're moving constantly toward resolution. We're speaking with prosecutors, an ongoing dialogue. We're engaging witnesses. We're setting up and identifying pretrial issues for pretrial motions that we can file. We're participating in the discovery process. We're doing everything we can to move toward a resolution on the case that's favorable for our client. That may be a trial. It may not be a trial. It really all depends on the strengths and weaknesses of the state's case and what we're able to gather and what we're able to do as defense lawyers throughout that process in strengthening and bolstering our case. We're going to take a brief commercial break, and we'll be right back with you.
You have been listening to attorney John Musca of Musca Law, with offices throughout Florida, including Broward and Palm Beach County. If you have questions about criminal law or related matters, call into the show at 1-888 565-1470. Join us every Thursday at 4 p.m. for Musca Law Radio, a program dedicated to all criminal defense matters. Joining us live now in our studio, here's attorney John Musca.
Thank you, Blake. Welcome back, South Florida, and listeners everywhere. Running into some difficulties streaming live on www.muscalaw.com. We expect to have that up shortly. I wanted to get back a little bit to what we were talking earlier about waiving appearances at court dates. I spoke earlier about misdemeanors. Typically, that is acceptable. We are able to waive your appearance at pretrial conferences and status checks. Felonies, ordinarily, though, not so fortunate. We can file a waiver of your appearance at the first court date, which is the arraignment date, but not ordinarily at subsequent court dates for felony charges, unless or until they're reduced to lesser offenses, when we could step in, obviously, and file waivers in those cases. I have joining me live attorney Marquin Renard, who is a 30-year criminal defense attorney, veteran. He's been practicing law for quite a long time. Marquin, are you with us?
I am, John.
Okay, thank you for joining us. Marquin, we're talking a little bit about the criminal law process. I covered the arrest, from the arrest to the arraignment stage to the pretrial conference stage on both misdemeanors and felonies. We're speaking about waivers. Waivers are ordinarily acceptable in misdemeanor cases, but not on felony cases. And we're talking about how we're moving toward the resolution stage, be it either a trial or a resolution vis-a-vis a plea. Once again, attorney Marquin Renard joining us live, a 30-year criminal defense attorney veteran. Marquin, I want to take a break from talking about the criminal law process a little bit and kind of just ask you about your experience as a defense lawyer. You're a full-time associate of Musca Law at this point, and I'd like to see how you would handle this question that a lot of people ask me, almost invariably, all the time. How can you defend somebody that you know is guilty?
Well, everyone has the right to be proven guilty, and our job as a defense attorney is pretty much, in my opinion, the checks and balance on the entire criminal justice system. Everyone has the job to perform. Everyone has the right, if they're charged with a crime, to be defended. And I'll start with, I can't say that I know someone is guilty. A person may come in and say, I've been arrested for this offense and I'm guilty, I did it, but they may have a misconception of what the law is and what the requirements are in order to actually be proven guilty beyond a reasonable doubt of a specific crime. So it's not really my position to have an opinion as to whether a person is guilty or not, but it's oftentimes difficult to know that a person is guilty because they really don't know if they've committed a criminal offense or not. But sometimes the criminal defense isn't about getting a person off, but it's about getting a just result in the case, a just result for everyone involved. And part of defense is to reach that goal, is to reach a resolution which is just. I certainly would not want to be judged on the worst day of my life, and oftentimes that's the case that we find our clients in, is that they are good people, they're honest people, they've been hardworking, they made a mistake. They had the worst day of their life. And I have no problems or difficulties at all defending someone or representing someone who had the worst day of their life, but it was an abnormal day for them, and to search out and to find mitigation and to present that mitigation to the prosecutors in order to reach a just and fair result for everyone involved. So it's not only that everyone is entitled to representation, but it's also that just because a person is charged with a crime and just because they might actually be guilty of that crime doesn't mean that they aren't entitled to have someone represent their interests to be their advocate, to present mitigation, to present their side of the story, and to reach the best possible result for them.
Thank you. Mark, when you've defended, you began your career as a public defender. How many years did you serve as a public defender?
I believe it was a total of about 16 or 17 years.
Okay, and in that capacity, you represented hundreds of people accused of a wide range and gamut of criminal offenses, ranging from simple misdemeanor, second-degree misdemeanor cases, breach of peace, all the way up to and including serious sex offenses, capital sexual battery, and the like. Correct?
That's correct.
Okay. And what would you regard as the most real challenge that you faced on any matter that you've represented? In other words, is there a particular case that stands out in your mind, or do you approach all the cases the same way? How would you respond to that?
Well, I would like to think that I approach all the cases in the same way, but that's probably not true. Not necessarily a specific case, but a specific type of cases. And the specific type of case would be those involving clients that have been charged with inappropriate sexual contact with children. Those are difficult cases simply because of the nature of the charge. The charge itself presents challenges as far as if you're going to go to trial and selecting a jury. There's often the jurors have in their mind questions that they want answered by the defense, even though the defense doesn't have a burden. And those questions are generally, why would a child lie or say something that happened when it didn't happen? And how would a child of a young age, anywhere from 8 to 12, 13 years old, how would they have knowledge of sexual acts unless the things that they're claiming happened to them actually happened? So the type of case is a difficult case simply because it's difficult on most occasions to get jurors who can put aside any preconceived ideas or notions that they have and to look at the case based solely upon the evidence that's presented and the law that the judge gives them. There are also difficult cases because you have clients that, you asked earlier about how do you defend a client that you know is guilty. Well, the tougher question is, how do you defend a client who you know is not guilty, that faces a serious charge like that, and you know that literally their life is in your hands, because if convicted they could go to prison for the rest of their lives. And you know in your heart, you know from what you have discovered through the evidence, that the allegation just isn't true. And it's not true perhaps because it's a child who doesn't like being under the restrictions of the parent and wants to find a way out of those restrictions. It's a child who unfortunately finds themselves in the position of being used as a pawn in a custody battle. It's those types of cases, the sexual cases that deal with child as a victim of a crime that I find the most difficult, because no matter what the circumstances are, there really isn't a winner in the case, and the child is ultimately a loser. The child is not going to come out victorious if the defendant is found guilty, and the defendant really did it. And there's some satisfaction, I suppose, for the conviction, but ultimately there's still a lifelong effect that's going to be on that child. If the child has made something up that's resulted in a client being sentenced to a period of time in prison, if the child was used by the other parent as a pawn, the child is still the victim in that case, and it's still going to have long-lasting effects on them. So the long answer, I guess, to your short question is that it's not really a specific case that comes to mind, but a specific type of case. And the cases that involve children as victims, especially in the sexual area of the law, are extremely difficult cases.
And each case, indeed, is a challenge. You have represented folks on serious sex crime allegations with no physical evidence, merely someone saying that it happened. Those cases would be flimsier than most, though, at that point, without physical evidence.
Those cases are the most difficult to deal with your clients on because they, like most people, think that, well, there's no evidence. They don't have an appreciation or an understanding that someone's word is evidence, and someone's word is enough as evidence to result in a conviction if that word is believed. But those are the most trying types of cases where it's involved in a he said, she said type of thing where the jury has to come to a conclusion as to who they believe and whether or not, if it's the alleged victim in the case that they believe, do they believe them beyond and to the exclusion of a reasonable doubt. Any parent who has more than one child knows how difficult it is if something happens in the house and you don't know which child did it, and they're both denying it. It's difficult at times to know which child is telling the truth and which child's not telling the truth.
And certainly there's other motivations involved too, Mr. Renard, that I've encountered many times. There's a split family. There's a divorced couple. One is trying to gain leverage by telling trying to coach the little girl or the little boy, for that matter. And I think it's important. Again, we go back to the same principle. All are presumed innocent unless or until the state is able to meet the burden of proof. We spoke earlier, I explained to the listening audience some time ago about the stages of the criminal process as far as the intake with the sheriff's office. The sheriff's office would gather the information, and then it would be moved on to the prosecutor to make a formal filing decision. There is always that limited window of opportunity in between the point of the arrest and the arraignment date, which is the date that the prosecutor makes a filing decision, for defense lawyers to possibly make a difference as far as influencing that filing decision to avoid criminal charges from being filed. And we have seen that in our office with those that have been accused of serious sex offenses or non-serious sex offenses, although I don't know any sex offense allegation that is non-serious. So, it is important if you're accused of any criminal offense, be it DUI, sex offense, drug-related matters, domestic violence, battery, crimes of aggression, it is important that you seek counsel as soon as possible. There is absolutely no benefit or value or advantage to delaying. The sooner the better. The analogy I use is it's like a cancer. The sooner you can get an attorney on it, the sooner your odds are of either beating it or at least mitigating the damage and keeping it under control. We're back live, 1470 WNN Radio in moments.
You have been listening to Attorney John Musca of Musca Law, with offices throughout Florida, including Broward and Palm Beach County. If you have questions about criminal law or related matters, call into the show at 1-888-565-1470. Join us every Thursday at 4 p.m. for Musca Law Radio, a program dedicated to all criminal defense matters. Joining us live now in our studio, here's Attorney John Musca.
Thank you again, Blake. Welcome back to the show, 1470 AM WNN. Joining me is Attorney Marquin Renard. Marquin, are you still with us?
Yes, sir.
Okay, thank you. We're going to segue now. We appreciate your comments on sex crime defense and how delicate those matters are. I am impressing upon the listening audience, all South Florida and elsewhere, of the importance to consult an attorney as soon as you can, as soon as one can. if they're in a position of being accused of any type of matter, really, but especially of the more serious nature. I want to thank you for joining us, Mr. Renard. Is there anything else you'd like to add?
No, I just enjoy the opportunity to be here, and hope that people will call with questions, because I think that there are a lot of questions people have and don't really understand about how the criminal defense bar actually works.
And Mr. Renard, that's exactly the purpose of the show, to educate the public. We're here every Thursday from 4 to 5 p.m. on WNN AM 1470 radio. We're going to transition now, and we're going to pick up and speak about something that's very dear to me, and something that I have a great deal of experience in, having virtually dedicated my career to representing folks on DUI-related matters. That seems to be always a hot topic, something that many people always seem to be discussing everywhere. Unfortunately, I think they're also consulting 1,000,001 different resources online and receiving the wrong information. I've handled many DUI cases in my career. I've managed, evaluated, assessed, and furnished advice on many of them. And the first question I get almost invariably, and again, it's a first program, so I'm citing the most common questions that I receive. We will dig deeper and focus on more specific areas of the law later on as we move forward. The most common question I get is, if I ever get stopped, do I blow or do I not blow? I have an answer for you, and some may hem and haw and not give you the right answer, but I'm going to tell you that if you have been drinking and you find yourself behind the wheel and you find yourself in the unfortunate situation of being stopped, you absolutely should not blow. Now, the next question becomes, well, won't I lose my license automatically? The answer is yes, but something law enforcement doesn't tell you when they're reading implied consent is that you will be entitled to a formal administrative review. In other words, you can challenge the DMV suspension that's handed down. So, for example, somebody is pulled over for DUI. The officers ask them to remove themselves from the vehicle, perform field sobriety exercises, and then they ask them to blow. The person declines. If you decline, if you refuse to blow, then your license is suspended for 1 year. If you do blow, and the legal limit in Florida, of course, is a .08, then your license will be suspended for 6 months. However, again, law enforcement has not been telling the accused and defendants in this situation for years that what you are entitled to is a formal administrative review hearing. And joining me live, if we can get her on the phone here, is attorney Rebecca Sinalia. Rebecca has dedicated her practice, or limits her practice, I should say, to representing people on formal administrative review hearings. That is one component of the case. If you're arrested for DUI, of course, there's also the criminal component. So it is very important to understand that there are two cases that are created anytime one is arrested under suspicion for DUI in the state of Florida. A DMV case and a criminal DUI case. And joining me live is attorney Rebecca Sinalia. Rebecca, how are you?
Good afternoon, Mr. Musca.
Thanks for joining us. Ms. Sinalia is a full-time associate of Musca Law. I'm pleased that she was able to take time off, and she is very busy, and I mean that, Rebecca. So thanks for joining us. Rebecca, what is the having dedicated all of your time basically to representing people on formal administrative review hearings? I discussed with the listening audience moments ago that law enforcement does not tell you that you're entitled to a formal review hearing. In the event that you blow over the legal limit, or if you refuse, you're looking at either a 6-month or a 12-month suspension, respectively. Why do you think law enforcement doesn't tell you that?
Well, just to clarify, Mr. Musca, there are differing periods of the suspension depending upon the history and facts of the case. If it's a first time for blowing over the limit, that would be a 6-month suspension. But if it's a second or subsequent offense for blowing over the limit, that would be a 1-year license suspension. And in the case of a refusal, a first time refusing the breath, blood, or urine test request, would be a 1-year suspension, whereas a second or subsequent refusal would be an 18-month license suspension. With regard to the law enforcement aspect of notifying an accused of what their rights are to challenge it, there's some fine print on the DUI citation that's issued to drivers in this situation that notifies the driver of the license suspension, as well as some fine print that indicates the location of the bureau that they can try to contact to try to do something about this. It's really not very informative, but of course the law enforcement officers do not feel obligated, and oftentimes nor are they qualified, to explain the legal ramifications of how one might go about challenging or addressing the license suspension that's been issued on the date of the arrest for either blowing over the limit or refusing to submit to the breath test. Well, what I find a little more interesting is the lack of information provided to somebody about the difference in the consequences if they refuse the breath test or as opposed to taking the breath test and blowing over the limit. The Florida implied consent law obligates the law enforcement officer to notify the driver that their license will be suspended 1 year for a first-time refusal or 18 months for a second or subsequent refusal, as well as some additional information with regard to the refusal being admissible in court, and if it's a second or subsequent refusal, that it can also be the basis of a separate independent misdemeanor charge in the criminal court case. But the difference in the length of the suspensions is something that's really very rarely ever addressed by the law enforcement officers. Typically, if a driver asks the law enforcement officer, well, I'm having trouble making this decision, somebody who's having, as Mr. Musca referenced earlier, the worst day of their life, and possibly even being intoxicated at that point, although certainly not all of our clients are intoxicated by any means, and they're saddled with a very important legal decision that has ramifications on their future. And the only information that they are being provided to help guide them or help them make the decision for themselves is that, okay, well, if you refuse this breath test, your license will be suspended for 1 year if it's your first time or 18 months if it's a second or subsequent refusal. And the driver, of course, may be thinking, well, what happens if I blow and it's over the limit? Law enforcement officers very rarely will answer that question for the driver.
Right.
And I think that's an unfortunate aspect of DUI law, that the driver is really forced to make such an important decision without having access to what I think would be important information to weigh the options and make a knowledgeable and intelligent decision. They oftentimes the driver is told before the breath test of what the consequence is for refusing. So the person may go ahead and submit to the breath test then, and then be very surprised to find out after they blow over the limit, well, your license is getting suspended anyway.
Right. That's and that's the point. That's the point I'm making there is when implied consent is read, by refusing to submit to the breath test, you understand that your license will be suspended for a 1 year period of time. Part of that implied consent does not indicate that they're entitled to a formal administrative review hearing to challenge the suspension.
You're correct. The implied consent law doesn't have any requirement that the driver be notified of what opportunities they may have to challenge it. When the person is making the decision of whether to blow or refuse, what they are read is a speech that states the driver's license consequences as well as the additional information about using it in court or it being the basis of a separate misdemeanor offense if it's a second or subsequent refusal. That's the information that is typically available to a driver when they are forced to make the decision of whether to blow or refuse.
That's right.
And it's only after the fact that they may or may not figure out that there are some opportunities, and that's why legal counsel is absolutely vital and it's extremely time sensitive as well. Action must be taken within the first 10 days following the date of the arrest, or any opportunity to challenge the suspension is gone forever, or to pursue any other avenues that may be available to the driver to seek some relief.
And the time-sensitive aspect is very important. Again, we had Attorney Marco Renard on the line moments ago, and I was indicating to him and the rest of South Florida here how important it was to secure counsel, obtain counsel, and get them on the case as early as you can. Nowhere is that reality more stark than in the context of the DMV hearing that's needed after a DUI arrest. So for questions, call 1-888-565-1470. We're live, 1470 MM Radio. 1-888-565-1470. I will say at this time where www.muscalaw.com has had difficulty with their streaming capability. We will be available and have that online for you next Thursday. In the meantime, you can go to www.wnn1470.com to watch us stream live now for the balance of this show. Any questions concerning the DMV part of the after DUI cases? Attorney Rebecca Sonalia has handled hundreds of these cases and is very fluent, experienced, and qualified to handle these types of matters. Moving on, the other component of the case is a criminal aspect, and Rebecca, I'll ask you to elaborate on the two real purposes of the formal hearing. First and foremost, to challenge the suspension, of course, and do everything that defense counsel possibly can to nullify the suspension. In the meantime, for the most part, the person will be entitled to a driving permit throughout that. And then the other purpose of the DMV challenge, of course, would be to generate as much evidence and testimony as you can. Can you elaborate on those two purposes a little bit?
Yes, I certainly can. I think it is very important for the listening audience to understand and to be absolutely clear that when you are arrested for DUI, there's two completely separate actions that have begun and will proceed. There's the criminal charge of DUI that will proceed in the court before a judge against a prosecutor who is called an assistant state attorney, and that assistant state attorney is saddled with the goal of trying to prove that the person has committed the law or violated the law and committed the offense of driving under the influence. But completely separate and completely independent of the criminal charges proceeding in the court, there's this automatic DMV driver's license suspension that's effective on the date of arrest for most DUI cases. There are a couple of exceptions to this, but by and large, the arrestee is typically going to have an automatic license suspension on the front end for either refusing to submit to a breath, blood, or urine test, or for submitting, and the results being over the legal limit of .08.
Very good.
In every respect, the criminal court case is completely separate and independent from the DMV driver's license suspension matter.
And we're gonna elaborate a little bit later on, Rebecca, on the criminal case, having already touched upon the DMV case. We do have Cliff that's calling in from Fort Lauderdale that has a question. Cliff, are you with us?
Yes. Hi. Good afternoon, guys.
Good afternoon. Thanks for joining us.
Very, very important topic. The question I have, which I have heard a lawyer mention before, that if you refuse the sobriety test and you refuse from blowing, they can arrest you, because they're going to arrest you anyway, but they can't charge you. Is that true? That's could you shed some light on that? I'll listen up here.
Cliff, I want to clarify your question. You indicated that if you refuse to blow, are they going to arrest you anyway? Is that your question?
Right. Or if you refuse the sobriety test, you're going to be arrested anyway.
Okay.
So they can arrest you, but they cannot charge you for that. That's what I heard an attorney said once.
No, that's false. They can arrest you. They will likely arrest you, and you likely will be charged. Cliff, as a general matter, when somebody is stopped and the officer develops suspicion that that the person is driving under the influence, from the very moment that the person is asked to remove themselves from the vehicle, the officer basically has his or her mind made up that the person is going to be arrested for DUI. At that point, from the moment that you exit the vehicle, what law enforcement is doing is marshaling together as much evidence as they can to lay the foundation for an eventual conviction. Period. That's.
Okay. I thought that due to the fact that you refuse everything, then what would be their evidence that you're
if you refuse everything, Cliff? In other words, if the DUI, if the breathalyzer is refused as well as the field sobriety exercises, that's what we loosely refer to as a double refusal. Then prosecutors go forward on that. They look at that as an act of defiance. As Attorney Sonalia mentioned earlier on your license, there's according to the prosecutor, there's something that indicates that by operating a motor vehicle, you impliedly consent to any field tests or sobriety tests required by law enforcement. So if you refuse the field sobriety exercises and the breathalyzer, then you will likely be arrested and you will likely be charged. It's up to your legal team then at that point to step in and take over. What I always say is the streets are public domain. What happens after that, it's up to your legal team. But to answer your question, Cliff, I appreciate it, and it's a great question. But to answer it, yes,
Thank you very much.
more than likely you will be charged. Thanks for calling in. We're going to take a quick commercial break, and we'll be right back. Thank you for joining us, South Florida, and listeners across the state and elsewhere. The streaming function, the streaming video of this will appear at 5 o'clock due to technical difficulties. The entire program you could watch on www.muscalaw.com. Click on the radio link and join us. Phone number 888-565-1470 is our number here. I just want to, in conclusion, summarize, and I thank Cliff for calling in earlier on today. Cliff brought up a good point. Don't give up evidence. The less evidence you give up, the better. You have an absolute unfettered constitutional right to remain silent. It's very, very important that you honor that. And we touched upon the legal process today. We're going to do this every Thursday from 4 to 5 p.m. right here on WNN 1470 Radio, 50,000 watt station, broadcasting live each and every time. I want to thank our guests, Attorney Rebecca Sonalia, full-time associate of Musca Law, as well as veteran defense attorney Mark Wynn Renard, 30-year veteran defense attorney. It's been a pleasure being here. Cliff, you are our first caller today. This is our first show, so we are going to be here for you. We want to educate the public as much as we can. God bless you all, and we'll see you all next week. Take care.
You've been listening to Musca Law Radio with attorney John Musca, with offices throughout Florida, including Broward and Palm Beach County. Join us every Thursday at 4 p.m. right here on 1470 AM, WNN, or log on to muscalaw.com and watch the program stream live. Thank you for joining us.